At the divorce hearing, my husband was full of arrogance. "You'll never touch my money again." His mistress smiled. "She doesn't deserve a single dime." The judge opened my letter, skimmed it, then burst out laughing. He quietly said, "Oh, this is good." Their faces went pale with fear. 15 years earlier, none of that existed yet. There was no company, no mistress, no letter. There was a scratched kitchen table in a one-bedroom apartment above a dry cleaner, and a man across from me who believed with a kind of certainty I found genuinely magnetic at 23 that he was going to build something enormous out of nothing. He'd majored in mechanical engineering and hated the internship that was supposed to lead somewhere respectable. I'd majored in accounting because I liked the idea of things adding up. No ambiguity, no argument. We met at a mutual friend's barbecue where he talked for 45 minutes about a manufacturing process he wanted to disrupt. I understood maybe a third of it. I remember thinking whatever he ended up doing, it would not be boring to watch. We married 2 years later in a backyard with a caterer who was really just his aunt and a borrowed sound system that kept cutting out during the vows. We didn't have money for anything else, and neither of us minded. He told everyone that night that I was the reason he believed any of this was possible. I believed him completely. The plan, such as it was, formed over that first year almost by accident rather than design. He would build the company. I would keep us financially stable while he did it because someone needed to, and my job paid steadily even if it wasn't glamorous. Once the business found its footing, we'd share in whatever it became. It wasn't written down anywhere. It didn't need to be. That's what marriage was supposed to mean. The company needed a bank account before it needed almost anything else, and he needed someone with an actual credit history to open it, since 3 years out of college with nothing but student loan debt to his name wasn't going to impress anyone. So I opened it. I sat in a branch office on a Tuesday afternoon during my lunch break, filled out the paperwork, and became the sole authorized signer on an account that, for the first 18 months, held barely enough to cover the domain registration and a second-hand laptop. I want to be honest about this part because it matters later. Opening that account wasn't a calculated decision. I wasn't protecting myself against some future I could see coming. I was doing what needed doing so my husband's company could exist, the same way I did 100 other unglamorous things that year because someone had to, and I happened to be the one with a checking account in good standing. When the company started generating enough revenue to need real payroll close to 2 years in, he asked if he could be added as a signer on the account. Of course, I said. I went back to the same branch, filled out another form, and added his name. It felt like the most natural thing in the world, 2 names on one account, because we were building one thing together. What never happened, in all the years that followed, was my name coming off that account. There was never a conversation about it. No moment where either of us decided the account should belong to him alone while I stepped back. It simply stayed the way it started because nobody had a reason to change it, and I never thought to ask why I still had signing authority over a business that, on paper and increasingly in conversation, was becoming entirely his. The first 3 years of the company were, by any honest account, brutal. There were months when revenue didn't cover rent on the small office space he'd leased against my advice. There were nights he came home and sat at our kitchen table with his head in his hands, convinced the whole thing had been a mistake. I'd make coffee. I'd remind him why he started. I'd pull out the spreadsheet I kept, tracking not just our household expenses but the company's runway, and show him we had 4 more months before anything became a real emergency. Somehow, we always found a way to stretch those 4 months into 6. My paycheck covered the mortgage on the small house we'd bought in year 2, the health insurance for both of us, the groceries, the utilities, and more often than either of us liked to admit, the company's software subscriptions and contractor invoices when a client payment came in late. I postponed the graduate degree I'd been planning since college because we couldn't afford both my tuition and the company's survival. I put off buying a car that wasn't held together with duct tape and optimism. I didn't take a real vacation for 4 years. None of this felt like sacrifice while it was happening. It felt like building something. Every dollar I redirected from my own plans into keeping us afloat felt like an investment in a future we were both going to share. He told me as much, constantly, in those early years. Once this works, he'd say, "Everything I have is yours too. You're the reason any of this is possible." I heard some version of that sentence at least once a month for the first 5 years of our marriage. I believed it. I had no reason not to. Everything changed in the company's 7th year, though it didn't feel like a single moment at the time. It felt like a slow tilt, the kind you only notice once you're already at a completely different angle from where you started. One of his products, a small manufacturing efficiency tool nobody expected to be the breakout, caught on with a mid-sized distributor, and within 18 months, the company had expanded into 3 additional states, trade publication features, a regional business award, an invitation to speak on an industry panel that he came home from vibrating with adrenaline. The shift was gradual enough that I couldn't have told you the exact week it started. Dinner conversations, which used to be an even exchange, slowly became something closer to a briefing. He'd talk for 20 minutes about investor calls and expansion timelines, and when I'd try to steer towards something in my own life, he'd nod along in a way that made clear he was waiting for his turn to keep talking rather than actually listening. He hired an assistant that year to manage his calendar and travel, and it struck me as faintly absurd that he now had professional help managing his schedule while I still handled every bill, every appointment, every piece of the household's actual infrastructure, entirely alone. When I mentioned, gently, that I'd been thinking about finally going back for the graduate degree I'd shelved 7 years earlier, he looked up from his phone with something that read, unmistakably, as confusion. "Why?" he said. Just the one word, flat, like the question itself was the strange part. I explained I'd wanted it for years, that we'd always talked about it as something I'd get to once things stabilized. paralyzed. He shrugged, dismissive for the first time in our marriage. Seems unnecessary now, he said, and went back to his phone. Business trips, which had always been a normal part of running a growing company, became more frequent and more oddly timed. Weekend plans we'd made months in advance got canceled with increasing frequency, always for the same reason. Work. It's just work. You're overthinking this. I want to be clear that I didn't spend those months in constant suspicion. I loved him, and the instinct that protects a marriage more often than it damages it is to believe the person you love when they tell you nothing is wrong. So mostly I believed him. I made excuses for him that were, in hindsight, remarkably generous. The moment that cracked something open happened almost by accident. While organizing paperwork for our accountant ahead of tax season, I found a hotel reservation for a trip he'd described to me as a 2-day conference 3 states away. The reservation was for 4 nights at a boutique hotel that didn't match the mid-tier chains the company typically booked. There was a second name on it, not a colleague's, not anyone from the leadership team I'd met a dozen times at company holiday parties. I didn't say anything to him that night. I sat with the receipt in my hands for a long time after he'd gone to bed, and I made a decision that would define the next several months of my life. I wasn't going to confront him. I was going to pay attention instead. Paying attention turned out to be its own kind of education. Phone calls he used to take at the kitchen table started happening on the back porch instead. Door closed, voice low. Text messages that used to sit open on his phone screen now got closed the instant he heard my footsteps in the hallway. His phone, which had never once in a decade of marriage required a passcode, suddenly did. I started keeping a small private log. Dates, small details, the hotel reservation, a dinner receipt for 2, at a restaurant an hour from the office, on a night he'd told me he was working late. A pattern started to emerge on the page in a way it hadn't quite managed to emerge in my actual daily life, where I was still, most of the time, telling myself I was imagining things. The conversation I overheard 3 weeks after I found that reservation removed any remaining ambiguity. I'd come home early with a headache, quieter than usual coming through the front door, and I heard him on the phone in his home office before he heard me. "I'll handle the divorce soon," he said, in a tone I'd never once heard him use, low and businesslike. "I just need everything positioned first." I stood in the hallway outside that door for what felt like a very long time. What stopped me cold wasn't that he wanted a divorce, though I was distantly shocked by that. It was the word positioned. He wasn't calling a friend to process a difficult decision. He was strategizing, and he'd already been doing it quietly without a single word to me. I went to bed, lay awake until nearly 4 in the morning, and made the decision that would shape everything that followed. If our marriage had already ended in his mind, the worst thing I could do was tip my hand by confronting him with what I knew. He had a head start. My only real advantage was that he didn't know I knew. The next morning, I called a divorce attorney. Not because I wanted a divorce, because I needed to understand, clearly and unemotionally, exactly what I was dealing with. My attorney was recommended by a coworker who'd gone through a difficult separation 2 years earlier. I sat in her office with the small private log I'd been keeping, feeling faintly ridiculous. She didn't treat it that way. She read through my notes carefully, asked sharp questions about the business, the account structure, who held authority over which assets, and by the end of our first hour, she'd laid out something I hadn't fully considered. "You've told me you're still the sole original signer on the business operating account," she said. "Is that still current?" "As far as I know," I said. "That," she said, "is significant. More significant than you probably realize right now." She explained, in the plain, unhurried way I'd come to appreciate about her over the following months, that in many jurisdictions, the character of a business asset in a divorce isn't simply decided by whose name is on the door or whose face is on the conference panels. It's decided by documented financial reality, who funded it, who had legal authority over its accounts, whose labor and capital kept it alive during the years it wasn't profitable. If I could document clearly and specifically the financial history of that company from its founding to the present day, I would be in a far stronger position than my husband currently believed I was in. "Start keeping everything," she told me. "Every bank statement, every tax filing, every email where he references your contribution, your labor, your money, even in passing. Don't confront him. Don't tip your hand. Just document patiently and let me worry about the legal strategy when the time comes." So that's what I did. For the better part of a year, while my husband believed he was quietly and cleverly positioning himself for a divorce he assumed would leave me with nothing, I was doing the same thing in the opposite direction, with considerably more paperwork on my side of the ledger. The retainer payment appeared in the business account 8 months after that overheard phone call. A modest 4-figure sum going out to a law firm I didn't recognize, listed on the transaction memo simply as professional services. I recognized the pattern immediately, since I'd been reconciling that account for over a decade. I knew every vendor, every recurring charge. This one stood out instantly. I looked up the firm that evening. Family Law, specializing in high-asset divorce and business valuation disputes. He was building his legal strategy, and doing it with money from an account that, as far as the bank's own records were concerned, still required my signature to move. I paid the invoice when it came due, the same as every other invoice, without comment, without letting on for even a second that I'd noticed anything unusual. I wanted to see how far he thought he could get. It turned out to be considerably further than I would have guessed. Mutual friends started calling me, one after another, with a version of the same conversation. "He's telling people the business is entirely his," one friend said, sounding uncomfortable even bringing it up. "He says you were supportive, but that you didn't really contribute anything he couldn't have gotten elsewhere. I thought you should know." I thanked each of them, genuinely, for telling me. I never once tried to correct the record with any of them. Never explained what I actually actually knew or what I was actually doing. Explaining myself would have meant showing my hand, and I'd decided, with my attorney's steady guidance, that the version of this story that mattered wasn't the one told at dinner parties. It was the one that would eventually sit in a folder in front of a judge. What I did do, quietly, was keep building. I requested full statement histories on the business account going back to its founding, organized 15 years of tax filings by year, and pulled every email I could find where he thanked me for my financial contribution or acknowledged in writing that the business wouldn't have survived without my income propping it up. There were more of these than I expected. One email in particular, from the company's 4th year, during one of its most difficult stretches, stayed with me the whole time I was building this case. "I couldn't have kept the doors open without you," he'd written, in response to a wire I'd sent from my own savings to cover a payroll shortfall. "Someday, everything we build here belongs to both of us." I printed that one and kept it at the very top of the folder. The detail that would end up mattering most, though, the one I almost missed entirely, came from something my attorney asked me to check as a matter of routine due diligence, rather than because either of us suspected anything specific. "Has anything changed on the personal accounts either of you hold individually?" she asked during one of our regular check-ins. "Not the business account. Your own personal banking, savings, anything in either of your names alone." I hadn't thought to look. I logged into the joint online banking portal that evening, more out of compliance with her request than any real expectation of finding something. Buried in the account management settings for one of our older joint personal accounts, one we'd opened years earlier and rarely used, was an authorized user listing I didn't recognize, a name that wasn't his. A name I'd seen before in passing at exactly one company holiday party 18 months earlier, introduced to me in a hallway as someone from the marketing team. I didn't understand the significance of it yet. I wrote it down anyway, added it to the folder, and kept going. The morning of the hearing arrived after nearly a year of quiet documentation, and I walked into the courthouse feeling something closer to calm than I'd expected. Not confidence exactly, just the particular steadiness that comes from having spent months preparing for a conversation you know is coming, rather than being ambushed by it. He arrived 20 minutes after me, in a suit that clearly cost more than the used car we'd shared for the first 4 years of our marriage, moving through the hallway with the loose, easy stride of a man who'd already decided how his day was going to go. Behind him, seated in the gallery once the courtroom doors opened, was a woman in a pale blue dress I recognized from the authorized user listing my attorney had asked me to check months earlier. She caught my eye once and offered a small, knowing smile. He leaned toward me in the hallway before we were called in, close enough that only I could hear him. "You'll leave here with nothing," he said, quietly, almost gently, like he was doing me a kindness by warning me in advance. I didn't respond. His girlfriend, standing a few feet away, laughed just loud enough for a couple of nearby people to hear and added, "She doesn't deserve a single dime." I said nothing to either of them. I found my attorney at our table, handed her the single sealed envelope I'd been carrying since that morning, and asked her to give it to the judge whenever she felt the timing was right. She nodded once, tucked it into her folder, and we waited for the courtroom to be called to order. His attorney went first, and I'll say this for him, he was good at his job. He laid out a narrative that was clean and confident. "My client built this company through his own vision, his own labor, and considerable personal risk," he said, pacing slowly in front of the bench. "While his wife was certainly a supportive spouse, there is no meaningful legal basis to characterize the business itself as a shared marital asset." When it was our turn, my attorney didn't raise her voice, didn't gesture dramatically, didn't do any of the things I'd half expected from courtroom dramas I'd half watched over the years. She stood calmly and said only that she'd like to submit a document prepared by her client, a chronological financial summary supported by records already entered into evidence during discovery. The judge asked what exactly it contained. "A timeline," she said. "Nothing more dramatic than that." He opened the envelope and began reading. I watched his eyes move down the first page, slow and deliberate, the practiced pace of someone who'd spent decades extracting meaning from dense financial documents. He paused once, went back a line, then continued. By the 3rd page, something in his expression had shifted, and by the 5th, he was making small notes in the margin of his own legal pad, cross-referencing dates against the exhibits already on file. The document itself wasn't emotional or accusatory, just a plain dated accounting of what I'd contributed across 15 years. The savings I'd withdrawn to cover a payroll shortfall in year 3, cross-referenced against a matching deposit into the business account the same date. The mortgage payments I'd made alone for 4 consecutive years while the company operated at a loss. And beneath it, copies of emails, his own words, thanking me across a decade for exactly the contributions his attorney had just claimed didn't legally exist. The judge worked through the exhibits already on file, comparing dates and figures against the corporate filings both attorneys had submitted weeks earlier. "You testified in your deposition," he said eventually, turning to my husband directly, "that the company became entirely self-funded after its first operating year." "That's correct," my husband said, though something in his voice had gone slightly less certain. "Then perhaps you can help me understand this transfer," the judge said, holding up a page. His attorney leaned forward to answer for him and started to say something about standard cash flow management before trailing off. The judge continued without waiting for him to finish. "This deposit into the business operating account matches, to the dollar, a withdrawal from your wife's personal savings account made on the same date," he said. "Was that a coincidence? Or was the company, in fact, still receiving personal financial support from her well beyond the first year you've described?" The judge spent several more minutes working through the timeline, asking pointed, specific questions that both my husband and his attorney increasingly struggled to answer with the same fluency transparency they'd shown at the start of the hearing. Finally, he set the document down, looked at both attorneys, and made his ruling for the day. Given the volume and specificity of the financial documentation submitted, he said, "This court is ordering a full financial review before any determination regarding division of business assets is made. I want bank records, tax filings, and corporate accounts from both parties examined thoroughly before we proceed further. We'll reconvene once that review is complete." It wasn't a final ruling, it wasn't the ending. But watching my husband's face as the judge delivered it, watching the easy confidence he'd walked in with drain away in real time, felt like enough of a victory that I let myself believe, for a few days at least, that the hardest part was already behind me. I was wrong about that, though I wouldn't understand exactly how wrong for another 3 weeks. The court-ordered financial review was supposed to be a straightforward matter of a neutral team cross-referencing everything the judge had just ordered against the documentation I'd already submitted, then producing a report he'd use to inform his final ruling on asset division. I spent those 3 weeks trying not to think too much about it, going to work, coming home to an empty half of the house since my husband had moved out shortly after the first hearing, waiting for a phone call from my attorney that would tell me the process was moving forward the way it was supposed to. What I hadn't accounted for was that my husband, even with his confidence visibly shaken in that first hearing, was not a man who simply accepted a setback and waited to see how things unfolded. In the years I'd known him, one of the qualities that had made him successful in business was a genuine inability to sit still when he sensed a problem forming. He'd always been the kind of person who started working an angle the moment he noticed one existed, and apparently a court-ordered financial review, however unwelcome, was simply another problem to be worked rather than an outcome to be accepted. My attorney called me 11 days into the review period, her voice carrying a note of caution I hadn't heard from her before. "Your husband's attorney reached out to opposing counsel this morning," she said. "They're offering a settlement, a fairly generous one on paper." I asked what generous meant in this context. 22% of the company's current valuation paid out as a lump sum in exchange for you withdrawing your claim to any ongoing ownership stake and agreeing to end the financial review before it's complete, she said. "It's not nothing. It's considerably more than his opening position at the first hearing." I sat with that for a long moment. 22% paid out immediately would have been more money than I'd ever had access to at one time in my entire life. It would have let me buy a small house outright, fund the graduate degree I'd postponed for a decade, build something that looked, from a certain angle, like exactly the kind of resolution most people would have taken gratefully and moved on from. "Why now?" I asked. "Why offer this now, in the middle of a review that hasn't even finished yet?" My attorney was quiet for a moment before answering. "Because he's worried about what the review is going to find," she said. "In my experience, when a party offers a settlement mid-review that's better than their opening position but still meaningfully below what the documented evidence supports, it usually means their side has identified something in their own records they'd very much prefer nobody examines too closely." I asked her what she thought that might be. "I don't know yet," she said, "but I'd like to find out before we agree to end a review that might be about to become considerably more useful to us than either of us currently realizes." I trusted her judgment enough by that point to decline the settlement offer without much internal debate, though I'll admit it wasn't an entirely comfortable decision. 22% in hand immediately was a real thing, a tangible number I could have held on to. What my attorney was suggesting I hold out for instead was something considerably vaguer, an unfinished process that might reveal something more, or might reveal nothing at all beyond what we already had. We declined the offer. His attorney called back within 48 hours with a revised number, 28%, which my attorney characterized as a genuinely significant jump for this early in a negotiation, the kind of jump that usually signals real underlying pressure rather than routine back-and-forth posturing. We declined that too. What happened next was the part I found hardest to process at the time, though it makes considerably more sense to me now looking back. My husband, through a mutual friend who still felt some lingering loyalty to updating me on things, apparently began telling people a new version of events, one that had shifted noticeably from the confident, self-made founder narrative his attorney had presented at the first hearing. This version was quieter, more defensive, focused less on what he'd built and more on the idea that I was being unreasonable, greedy, unwilling to accept a fair and generous offer, dragging out a painful process for reasons that could only be vindictive. I heard the clearest version of it secondhand from a friend who'd been at a dinner party where his name came up. Someone had asked, apparently, whether the divorce was finally settled, and he'd said no, not yet, that his wife had turned down a genuinely generous offer twice now, and seemed determined to drag things out as long as possible. Someone else at the table, a mutual acquaintance who didn't know the details, had reportedly said that sounded exhausting for him, and he'd agreed, visibly, sadly, in a way my friend described as almost convincing if you didn't already know what I knew. I want to acknowledge that from a certain distance, it's not an unsympathetic story to tell about someone. A wife who won't take a generous settlement, who insists on continuing a legal process instead of simply accepting a life-changing sum of money and moving forward. I understand why some people who heard that version found it more believable than the alternative, which required understanding financial documentation most people never think about until they're forced to. He was good at that. I'd learned over 15 years. He'd always been good at telling a story that made sense to people who only had 10 seconds to hear it. There was a strange, suspended quality to those weeks that I've had trouble describing to anyone who wasn't living through something similar. My husband had moved out, technically, into a corporate apartment his company kept for visiting clients, but we still crossed paths occasionally at the house when he came to collect things he'd forgotten, or at our accountant's office once. once, both of us there separately to handle year-end paperwork that hadn't yet been formally divided between us. Those encounters were polite in a way that felt almost more unsettling than open hostility would have. He asked how I was doing. I told him I was doing fine. Neither of us mentioned the settlement offers or the review or any of the actual substance of what was happening between us. And I remember standing in the parking lot after one of those encounters thinking that I no longer had any real idea what he believed about his own situation. Whether he genuinely thought he was the reasonable one being wronged, or whether some part of him already suspected what the review was about to find and was simply performing confidence for an audience that included, eventually, himself. His attorney called mine one final time before the second hearing, a week out, with a number she told me about with a small private note of something that might have been amusement. 35%, she said, which tells me they're genuinely worried now, not just posturing. Men who are confident in their position don't move a number that far, that fast, without a reason. I asked her if she thought he knew. I think, she said, choosing her words carefully, that he suspects something is wrong. I don't think he knows exactly what or exactly how much of it we've already found. If he did, I doubt he'd still be offering a settlement at all. He'd be trying to negotiate something considerably more complicated than a percentage. We declined the third offer, the same as the first two, and I spent the days leading up to the second hearing trying to occupy myself with anything other than counting down toward it. I went to work. I had lunch with a friend who didn't ask about the case, which I appreciated more than I could have told her. I read the same 3 pages of a novel probably a dozen times without absorbing any of it. One evening, close to the end of that stretch, I found myself going through the private log I'd started keeping months earlier, the one that had begun with a hotel reservation and a strange feeling in my stomach and had grown, slowly, into something considerably more organized. Reading back through it felt like reading notes left by a version of myself who hadn't yet known how any of it would turn out. Someone still operating on suspicion and instinct rather than the confirmed weight of a forensic accountant's findings. I remember being struck, reading those early entries again, by how careful I'd been even then, how methodical, long before I had any real reason to believe methodical would matter. I closed the notebook and didn't open it again until the morning of the second hearing, when I brought it with me out of habit more than necessity, since everything in it had long since been folded into documents considerably more official than a private log written in the evenings at my kitchen table. What none of those people knew, because I hadn't told any of them, was that a financial review that started as a routine cross-check of dates and figures had, over the preceding 2 weeks, begun to uncover something that had nothing to do with the business at all and everything to do with a personal account neither my attorney nor I had initially thought to examine closely. The forensic accountant on the review called my attorney 11 days into the settlement back and forth. I wasn't on the call, but she relayed it that evening with an expression I hadn't seen on her before, something closer to genuine surprise than her usual neutrality. He'd found something neither of us had asked him to look for, since neither of us had known it existed. His team had pulled transaction histories for every account linked to the business operating account in the bank's own systems. There was a personal account, she said, technically in my husband's name alone, but linked at the routing level to the business account, allowing transfers between the two without fresh authorization each time. It had a second authorized user, added years earlier, whose name matched the one I'd written down in my private log months ago, buried in the settings of an old joint account we rarely used. I'm telling you, she said, that this is going to the second hearing, and I want you prepared for what it might mean. The second hearing was scheduled for the following month. My husband, as far as I could tell, had no idea any of this had been found. As the date approached, his attorney sent a third settlement offer, considerably more generous than the first two, which my attorney characterized, dryly, as the offer of a man who suspected something was wrong but had no idea how wrong. We declined that one too. The morning of the second hearing, the courtroom felt different from the first, though I couldn't place why until my husband walked in. He looked tired in a way he hadn't looked before, the confidence that once made him lean toward me in the hallway and promise I'd leave with nothing noticeably absent. His girlfriend wasn't in the gallery this time. The judge acknowledged receipt of the completed financial review and asked the forensic accountant, present to testify, to summarize the report for the record. Your Honor, he began, our review confirmed the documentation previously submitted regarding 15 years of financial contribution to the business. In the course of that review, we identified an additional account structure, not part of the original discovery materials. He laid out the existence of the linked personal account, transfers from the business account categorized as legitimate expenses, and the signature requirement that had governed the business operating account since its founding, a requirement not satisfied for any of the transfers in question. My husband's attorney rose to object to characterize the account as a legitimate business arrangement, an accounting oversight rather than anything more serious. The judge listened, then asked a single question that seemed to end the discussion before it had really begun. Turning directly to my husband, the judge asked whether he'd been aware that transfers exceeding the authorization threshold on the business operating account required his wife's signature, given her status as an original account holder. My husband didn't answer immediately. When he did, his voice had none of the certainty it carried during the first hearing. I believed the account structure had changed, he said. It hadn't, the judge said. My signature authority had remained continuously in place since the account's founding, a fact confirmed by the bank's own records and never altered by either party in 15 years. The room had gone very quiet, the particular quiet of a courtroom watching a story rearrange itself in real time. The judge asked the forensic accountant one final question before setting the report aside. Can you confirm Confirm for the record, he said, the specific routing details connecting the business operating account to the personal account in question. The forensic accountant confirmed the account numbers and noted that the routing number on the personal account matched exactly the routing number on record for the business operating account, flagged automatically once the review began cross-referencing the two. The judge looked up from his notes, first at my husband, then briefly at me, and then back down at the report in front of him. I have to say, he said, and something in his tone had shifted into a register I hadn't heard from him before. Quieter, almost amused in a way that felt entirely at odds with the gravity of what was being discussed. This is considerably more thorough than I expected when I ordered this review. He turned another page, read for a moment longer, and then, unmistakably, he laughed, not loudly. A short, low sound, more disbelief than genuine amusement. The kind of laugh that escapes a person who has spent decades in a courtroom and still occasionally encounters something that manages to surprise them. Oh, he said quietly, mostly to himself, this is good. My husband's face had gone the color of the folder sitting open in front of him. Beside him, his attorney had stopped writing entirely, pen resting against a legal pad now covered in crossed-out lines, apparently recalculating everything he planned to argue next. The judge set the report down and looked at both attorneys for a long moment before speaking again. Given these findings, he said, the court will treat the transfers in question as unauthorized withdrawals from a marital business asset made without the required signature of a co-authorized account holder. That characterization will inform the division of assets going forward, effective immediately. He turned to my attorney. I'd like updated figures reflecting the full value of the business, including the unauthorized transfers as recoverable assets, submitted within 10 days. My attorney said she'd have them ready sooner than that. Opposing counsel asked quietly whether the court would entertain a brief recess before proceeding further. The judge granted it without much comment, noting only that he expected both parties to use the time productively rather than simply regrouping. I understood, without anyone saying it directly, exactly what that recess was actually for. My husband hadn't said anything since admitting he believed the account structure had changed. He sat very still, staring at a point somewhere past the judge's bench, the posture of a man doing arithmetic he badly didn't want to finish. I didn't look at him for long. There wasn't anything left in his expression that I needed to see, and there wasn't anything in his attorney's face beyond the particular blankness of someone realizing, in real time, that the argument he'd prepared no longer applied to the facts on the table. The judge gathered his papers, glanced once more at the routing numbers the forensic accountant had confirmed for the record, and allowed himself one more small private note before formally calling the recess. 15 years, he said, mostly to himself, is a long time for a signature to keep meaning something. Then he called the recess, and the room began, slowly, to empty around us. My attorney touched my arm once, briefly, and told me she'd meet me in the hallway once she'd finished a few things with the clerk. I sat where I was for another moment, in a courtroom that was quickly becoming just a room again, chairs scraping, papers shuffling, the ordinary sound of a building returning to itself after something enormous had just happened inside it. Somewhere behind me, I heard my husband's attorney speaking to him in a low, urgent voice, the specific tone of a man trying to salvage a conversation he no longer had any good options for continuing. My husband didn't answer him. He was still looking at the folder, or past it, or through it, at something I couldn't see from where I sat, and no longer had any particular interest in imagining. A clerk moved past our table, gathering exhibits into a numbered folder for the record. The forensic accountant closed his own laptop, unhurried, and gave me a small professional nod on his way out, the kind you'd give anyone whose case you'd just finished testifying on. Nothing more and nothing less. My attorney was still speaking quietly with the clerk near the bench, her voice low and entirely businesslike, already moving on to whatever came next procedurally, already thinking, I strongly suspected, several steps further ahead than I currently was.